All right, good evening, folks. Welcome to Monday Night Law here, December 11th, 2023. Man, year's coming to an end, folks. It's a coming. The days are running short. Let me see, I can get over here onto Rumble. There we go. Let's do a quick audio check here. Everybody got their audio? Testing, 1, 2. Or it should be testicle, 1, 2. All right, tonight's going to be a pretty good one, guys. I found an essay on the right to trial by jury by Lysander Spooner. Another one of those names that, gets into some of this stuff, so I gotta go find it. And this is entered into the record essentially in Massachusetts District Court, and then by an act of Congress compiled in under an act of Congress. So it's part of a record, essentially. So, for many years, I've talked about this right to trial by jury and the fact that we're supposed to judge both the facts and the law. I have found it in Texas's Article 1, their Declaration of Rights, that the jury is supposed to judge both the facts and the law under. And they hide it with the libel and slander under freedom of speech being responsible. Again, folks, I want to try to correct our language, diction. It's the proper word is responsible, not accountable. It has to do with accounting. Responsible is being able to be responsible, held responsible for their actions. Okay, so I'm kind of going into a new self here and really trying to make sure that everybody knows the proper words to use. Proper diction is very, very, very important, because diction, words, when coupled with jurisdiction, law. So we have to be very, very, very careful with what words we speak and that we use, because it can put us under a certain body of law. That's what jurisdiction is, body of law. So, this is my new venture, I guess, making this to a point of where I really need to break everything down for everybody because of the dumbing down of America. And words have meanings, and it depends on your source. And so this is very vital. There's a lot of people out there that are law gurus out there, or think they're law gurus, and I have utmost respect for some of these people. But I found that the choice of law, choice of jurisdiction, is in error. And we need to go to, depending, for the Constitution, for primary example, the New York State Rifle and Pistol Association versus Bruin case out of New York. It went all the way to the Supreme Court. And the Supreme Court said, we don't care about anything after 1791, when the Bill of Rights was written, when the Second Amendment was written. We want to go back to the original intent of the founders who wrote the Second Amendment when they wrote it. Okay, and I've been reading through some of the amicus brief and stuff, and what do? They're citing a history of statutes, or so-called statutes, code. This is the bar game, right? Fundamentally altering the law through legislation, pretended acts of legislation, no less. And they didn't really cite any history of rights, bills of rights, or anything like that. I mean, they did cite the one amicus brief that I was reading. They did cite the English Bill of Rights, from 1689. Great. So you found one Bill of Rights throughout history, which is, it is a good Bill of Rights. But why didn't you go to the Virginia Declaration of Rights, June 12, 1776? Why didn't you cite any of the early constitutions throughout history prior to 1791? Oh, because that's not the barcode game. Okay? This is all bar trickery, and I'm telling you again, folks, I'm telling you again, we're under a continuity of government. This is provisional government set up by Trump as commander-in-chief, not as president. Okay? Two separate powers. And Article 4, Section 4 backs this up, as well as Texas v. White, that the president, only acting as commander-in-chief, has the authority to set up provisional government pending the outcome of the war. Okay? What is provisional government? Well, when you have corruption, right here, reading from Montesquieu's Spirit of Law, and reading Blackstone's commentaries on law of England. Man, these are such good reading. It is so good. When dealing with corruption, even just one principle gets corrupted within the government, it turns into a bad government. What is the duty of the military? This is so key and vital to understanding everything about everything that's going on right now in our entire world. Okay? Executive Order 13818 is the most important executive order that we can even begin to pay attention to when it comes to war, because that is the executive order that essentially declares war because we were already at war. That's the key, another key here, essentially since 1861. So, the Civil War essentially has never really ended. And I'll even take you clear back to 1776. Essentially, the Revolutionary War has never really ended, because the corruption hasn't been taken down. What is that executive order about? Well, the title of it is blocking the property of those involved in serious human rights abuse and corruption. Corruption, governmental regimes. And again, the names that are listed in that executive order were the heads of Saudi Arabia. Saudi Arabia was the first hit. They went in, the military went in, took down the bad governmental regime, instituted new government, the democracy, held elections, and then did a treaty of peace. That's how that went. Now, there has been many other nation states, countries that this has happened to. It's not in the mainstream media. Okay? Nowhere. You're not going to find this in the mainstream media. I mean, there's little clips of it, hints of it. The sword dance when Trump walked in front of the Queen in England, when Trump stood next to the Pope there, you remember? How that Pope was not all smiles and smoking and joking like he was with all the previous presidents, because the gig was up. Okay? And, Jan Halpert, she reiterated this. 650 planes to retrieve all the gold. The Vatican, I found some article on that quite a while ago about how the Vatican had been raided 6 times already. Okay. Whether you're aware of that or not is irrelevant. That's what happened. We're taking back the gold. We're shutting down the whole in trust thing. And it's coming. It's time to give back what was held in trust to the people. And if you think that this is something easy, just that part. I mean, let's not even talk about, let's not add in there going to war and taking down bad governmental regimes by trying to, stay quiet about it. so everybody else doesn't figure out what's going on. The thing is, we have to recognize that this is what is going on. I know that there's a lot of skepticism, and I get it. Those that kind of have been paying attention for several years are used to the lies. They're used to being lied to by this so-called president or other elected officials. It's just flat out. I get it. It's just a flat out lie, right? But this is different, folks. There's actual little bits and pieces of evidence to support the claim that it is really happening. Okay? I can most definitely I've already played devil's advocate in my head. But given who I've been working with since 2017, the things that we've accomplished, the things that have happened, and man, I tell you, some of the paperwork that was filed is a direct relation to some of the things that's happened already. So, I know firsthand some of this stuff. And I have a couple of sources that, they can't come right out and tell me exactly what's going on. But they definitely hint at certain things, and I have to put the pieces of the puzzle together and figure it out. But that's not hard for me to do. I have this natural ability to kind of just, like a common sense thing. But only because I've gone down lots and lots and lots and lots and lots and lots and lots of rabbit holes since 1995. So, you have a choice. You can believe me or not, or that's irrelevant. Whether you think it's just my opinion or it's my opinions are based on facts, supporting facts, which I've shared. That's one of the primary differences between me and so many people, is I actually show evidence to support my claims. And I've showed it many times now. I've showed the executive orders. I've showed the video clips of Trump walking in front of the Queen, Jan Halper talking about it. They showed video clips. If you're paying attention, I'm preaching to the choir, I get it. But there's a lot of people out there that are new to waking up. But I'm glad you're here. Because we do need the people to wake up to reality, the truth, facts. All right. So, well, Karen, glad to see you on here. It is a fundamental change in the courts, and it's on the federal level, right? Because those are, whether people realize this or not, but the federal courts are under admiralty and maritime jurisdiction. Those are military tribunals. Per the Constitution. But again, this is something that the commander-in-chief has the power to set up provisional government. He's slowly taking over, right? Little bit at a time. And what it boils down to is the power of the people. We have to learn how to tell on. You want to clean this corruption up, folks, in your local area? We have to tell on them. You've got to gather the evidence. You've got to submit it to the right places. And I'm going to reiterate about the DOJ again, pursuant to Executive Order 13844, where he set up that provisional government per executive order. And that's basically a whole new attorney generals, deputies. So what essentially has happened there, because Congress finally dealt with the executive order and basically took the old DOJ, threw it out, and implemented the new DOJ. Now, this goes back to the video that I shared here just 3 weeks ago. Okay? That they're all of a sudden, they're doing an investigation, and I'm going to reiterate this again, all the way down to a traffic stop to see if it violates any of our rights or the Constitution. Why would they even mention all the way down to a traffic stop? Because that's a fundamental right of personal liberty. And I can tell you right now, some of this stuff is from them watching my shows right here, right now. You know, I was skeptical about it in the beginning of all this, but there's been sufficient evidence, proof, as well as given who Chris was talking to and working with, and given what we've been told by certain individuals, certain people, that they're watching our shows to learn, and more specifically me, watching me to learn from me, because I'm the one that brings the law. It's the way I've always been, before I even met Chris. So, you know, research and studying law, history of law, facts of law. And I show it on the screen. I share it with you folks every time. Just like I'm about to show you right now. Facts of history of law regarding the right to a trial by a jury. So who's ready to learn about trial by a jury? Yeah. Part of the powers belonging to the people, retained by the people. And this is a very good indicator of, back to the Declaration of Independence, depriving of us of the benefits of trial by jury. How many of you are aware of what are the benefits of trial by jury? Would it be to judge the law that's been deprived? You're about to see some of the very interesting things of what what these benefits of trial by jury are, and how they've subverted it over time. And I'm just going to go through the first few pages on this, but I can tell you right now, this, oh my gosh, just blows my mind. I mean, it's everything that I've already said before in little bits and pieces. It's so good, folks. You ready for this? All right. This is the essay. An essay on the trial by jury by Lysander Spooner, 1852. And then right there where I just had it. Entered according to Act of Congress in the year 1852 by Lysander Spooner in the clerk's office of the District Court of Massachusetts. All right. Interesting that he invokes the common law in this notice. The author claims the copyright of this book in England on common law principles without regard to acts of parliament. And if some of this is cut off, so if the principle of the book itself is true, that no legislation in conflict with the common law is of any validity, his claim is a legal one. He forbid anyone to reprint the book without his consent. Now, just for my own personal notice, this is not a reprint, and this is for educational purposes, and Obviously, that's what Kirk's Law Corner LLC is all about, is education, news. Let's just jump right into this. We'll go over the contents real quick, but the right of juries to judge the justice of laws. So we got section 1, section 2. Chapter 2. The trial by jury is defined by Magna Carta. Whoa, how many times have I said that the right to trial by jury actually comes it is in the Magna Carta, but it actually is the Aziz of Clarendon of 1166. Aziz meaning 12. So this is where 12 men comes from. Aziz. Let's see, the history of the Magna Carta, the language of the Magna Carta, additional proofs of the rights and duties of jurors. I've only made it down to like page 11, and I can tell you just in the first 11 pages is all just right in your face. The facts lays this stuff out. Almost don't even need to read any of the rest of it once you grasp the concept of what a trial by jury is all about, and what the powers of the jury is, and how it's supposed to work, and the evidence of what a corrupt government is. If they do this, if they do that, So those of you that have ever been through a trial by jury, like myself, which I just recently conducted my own trial by jury, what was that, December? My dates are off. It's November. It was November, pardon me. November 9th. Okay, and I've done another trial by myself before. But, so that's the second one I've done. But the first one wasn't a trial by jury. But this one was an actual trial by jury. And again, the judge commended me specifically that I did a good job and blah, 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 blah. So he recognized that I know some stuff. I know how to conduct myself in a situation where there's supposed to be decorum, right? And this is the key to all of this, is keeping your composure, remaining in honor the whole time. I've been guilty of this myself, going off on these judges and that kind of stuff. And I've learned this is the walk softly and carry a big stick. Okay. And it's helped me tremendously because, one, knowledge is power. I've gained this knowledge. Now it's time to utilize it and conduct myself in an honorable manner, no matter how dishonorable they act. I just smile. Move on. Make my objections. Every time I make an objection, that is an appealable issue. That is an error in the court. Okay? So this is why it's so key to understand who you are, where you're at, and what you're doing, and be firm in what you're doing, and object to everything that's not lawful. And it doesn't matter. It does not matter what they do. If you've objected, asserted the law, and what they're doing is unlawful, that is in the record. Pardon me, on the record. If you do it in writing, that's in the record. And some people will say in the certain states and stuff, well, it's not a court of record. No. Your paperwork is the record. I could care less whether they claim it's a court of record or not. The documents become the evidence that we have followed due process of law and given them notice and afford them the opportunity to do the right thing. Okay? So we have to recognize that, right? No. Evening shining light out on Rumble. All caps, false prophet, do not argue. No, you always make your argument. Always make your argument. Argument does not mean fighting. See, here we go again. Proper diction. What does it mean to argue? Essentially, it's a debate. You make your points, your argument in support of the claim. And then it goes to the other side. And they have a chance to rebut that with their argument and present their facts, their evidence. That does not mean fighting. So many times you hear people say, husband and wife, boyfriend, girlfriend, whatever, co-worker, whatever. Oh, we got in a big old argument today. You did? Who won the debate? So, yes, we most certainly want to make the argument. Always. Because that's your clear, concise statements of facts. So, like when I argued that the right to trial by jury consists of 12 men, what did I cite as my source of law? The Virginia Declaration of Rights, June 12, 1776. That was the evidence to support my argument that they're depriving the fundamental right of trial by jury. One of the benefits of trial by jury. So, that's an appealable issue. I even went ahead and did it in writing according to the rules of procedure. That even after you've done the oral, you can do it in writing. I like it in writing because then it forces them to put it in writing. And that's what I use as evidence. I'm just here following the law, and I'm documenting every little thing that they're doing that's unlawful. And I'm gathering that as evidence. And then when I go to tell on them, well, they're going to have a nice little vacation stay in Gitmo. Because that's how this works, because we're at war. But you have to know how to get there. You got to go to Congress. You got to file the criminal complaints. This is part of that provisional government set up by Trump. Whether people realize this or not, again, is irrelevant. These are facts. I'm trying to let people know and educate the people on what the very narrow path to get this, what the remedy is due process of law, is remedy, to get the relief that we seek. And it's a very narrow path right now. Because everything is so corrupt. But I'm telling you folks, it's crumbling. It is crumbling all around. And if you're tired of the corruption like I am, learn this stuff and do something about it. Stop complaining about it and do something about it. Take action. Follow due process of law. Okay? Article 4, Section 4, guarantee Republican form of government to protect us from invasion and domestic violence, which is internal insurrection, corruption. They're involved in serious human rights abuse and corruption. That's who the military's going after. But you got to learn how to get there. Got to go through the proper channels. Okay? Yeah. Got a name out here on YouTube, Awaken, says Trump is 100% part of the corrupt agenda. Taking down the corruption? Yes. Clearly, you haven't been paying attention. This is what I'm talking about, people. These are trolls. Because there's no way anybody out there who's been paying attention, not to me, but just in general, knows that we're at war. And that executive order means what it means, is taking down bad, corrupt governments, bad governmental regimes. It's already happened. It's already been happening since 2018. That's fact. How do you do a treaty of peace if you're not at war? I mean, completely illogical. So there you have it. Facts. All right, let's get back into this. There's a lot more here to read, right? But Trial by jury, Chapter 1, the right of juries to judge of the justice of laws. Now, for those of you that may have read the beginning part of the Constitution for the United States of America, it says, "We the people, in order to form a more perfect union, we the people establish justice." Oh, that means that we the people establish justice. Ensure domestic tranquility. That's in part what this is about. The whole purpose behind the trial by jury is to ensure domestic tranquility. That we don't have government officials trespassing on our property, our rights. Period. That's what that, to ensure domestic tranquility, is the power retained by the people. So here we go. What's some of them powers, and how does that work in a trial by jury? For more than 600 years, that is since Magna Carta in 1215. Now, this is as of 1854 or whatever, 56 or whatever it was there. Got so many 1850 something, I can't remember which one's which. And I want to be precise here. It was 1852, but this was published in 1852. So 1852, he's talking about 600 years since the Magna Carta in 1215. There's been no clear principle of the English or American constitutional law. Now let's change that just a little bit. Common law, because principles are part of the common law. But then that in criminal cases, it is not only the right and duty of juries to judge what are the facts, what is the law, and what was the moral intent of the accused. What was the moral intent? Gee, would that be part of mens rea, that the mind was guilty? And per the law of nature, one of the very first fundamental principle of the 6 primitive laws of nature is when man is properly organized, he knows the difference between moral good and moral evil. So that's what this is about. Where was the moral intent? Was it good or was it evil? But that it is also their right, and I'm going to blow this up, because I know that's probably pretty small out there. That should make that. Yeah, okay. Good question out here from Alaska. Jury of 12 men. Does that exclude females? Yes. Now, I know. Here's the thing. When you go with the Christian customs and the custom of the family, the man is the head of the household. He's the king of the castle. His wife is his queen. When it comes to like voting, right? You technically speaking only have 1 vote per household. And the man is the one that's supposed to cast the vote. So many people, are so happy about women's rights to vote. I think we would be better off not having women in politics. That's just my personal opinion. It was also a very highly held opinion of many of men throughout history, even good men, right? Now, here's the other part to that is that I think our wives are a very, very good other part. I mean, it becomes this, when you get married, it's a union of souls. So you become one, in essence, for God's law, his intent. So many of the founders wrote to their wives and talked with their wives. That's what we should be doing. We should be consulting with our wives. And I like to say that women are more of the emotional creature and men are more of the logical creature. So you have, when you combine both, you come up with an emotional logic. So if that makes any sense, it's not an oxymoron. It's a union. And so, where some men are very logical like myself, and we exclude the emotional side of things, but when you bring the emotional side of things into certain situations, it could be, it's still logical, but you're changing the logic because you have another variable, just like in mathematics. Okay? So, that's just my personal opinion, based on history of law as well, that women shouldn't be in politics. And there's a lot more reasons behind it, because women are a little bit more delicate than men, and they do tend to act emotionally or react emotionally and not logically. Although there's quite a few men out there that do get pretty crazy. But hopefully that's a good enough answer there. Then add a Karen, right? Yep. All right. Let's go back to the beginning. But that is also their right and their primary and paramount duty to judge of the justice of the law and to hold all laws invalid that are, in their opinion, unjust or oppressive, and all persons guiltless in violating or resisting the execution of such laws. This is, basically done so that we, in the American common law, but starting with the Magna Carta, this whole thing with having the jury was to protect the innocent. For example, false allegations. Or, as we have done this, as we've made it so that the people retain this power to provide oversight of that which they created, which means the people are the sovereign. And we endowed public servants with a certain level or certain amount of sovereignty. They do not become the sovereign. Only to a certain extent with that which they create. But if the people have all political power and they create the instrument of government that serves them, the people are the sovereign over that which they create. But let's keep going here because, man, this is good. Unless such be the right and duty of jurors, it is plain that instead of juries being a palladium of liberty, a barrier against the tyranny and oppression of the government, they are really mere tools in its hands for carrying into execution any injustice or oppression it may desire to have executed. But for their right to judge of the law and the justice of the law, juries would be no protection to an accused person, even as to matters of fact. For if the government, listen carefully, folks, and see if this applies to anyone here today, or you've had this effect on you. In a criminal case, it can certainly dictate to them the laws of evidence. Let's back that up again. For if the government can dictate to a jury any law whatever, in a criminal case, it can certainly dictate to them the laws of evidence. This is something can dictate what evidence is admissible and what inadmissible, and also what force or weight is to be given to the evidence admitted. I just kind of experienced that. And if the government can thus dictate to a jury the laws of evidence, it can not only make it necessary for them to convict on a partial exhibition of the evidence rightfully pertaining to the case, but it can even require them, listen carefully, because this is what's going on, to convict them on any evidence whatever it pleases to offer them. That's exactly what's happened. That the rights and duties of jurors must necessarily be such as are here claimed for them will be evident when it is considered what the trial by jury is and what is its object. The trial by jury, then, is a trial by the country. What do you mean of the country? Not county, country. Remember when I told you, and I showed it out of the Law of Nations, that a nation is composed of all of the countries? We are countries, not states. It was anciently called... Oh, wait, I didn't even finish that. Got sidetracked. The trial by jury, then, is a trial by the country. That is, by the people, as distinguished from a trial by the government. That's why they call that a jury trial. Because they actually can't call it a trial by jury. You have the right to a jury trial. See the diction? See the change of the phrase? This is a trial by a jury, not a governmental jury trial. Imagine that. Just the change. Just that simple little change. Did anybody even notice? Shining light out of Canada. Yes, absolutely. Law of nations applies to all nations, as regarded as international law. And again, the full title of the Law of Nations is the Law of Nations, or the Principles of the Laws of Nature as applied to the conduct of nations. And the Law of Nations is regarded as international law. But again, the real problem is the fundamental law, which would be the Law of Nations, the laws of nature, and American common law, has been altered, has been changed, swapped out for the Roman civil law, the Code. I mean, it's a whole different jurisdiction, a whole different body of law, as it regarded as the fundamental law. So that's what's happened essentially worldwide. good old Roman Catholic Church. And yes, Rome is behind all of this. The Jesuits, plain and simple. They're the ones that want world domination. Go look up the Jesuit oath. They want to kill anybody and everybody who doesn't, submit to their jurisdiction, their Roman civil law, their code, their religion, Catholicism. If you're not aware of that, go right ahead and just do a quick Google search for the Jesuit oath and read that sucker. And you should open your eyes pretty quick. And then learn that it's all about the Roman Empire, the Roman Catholic Church, Catholicism. Sorry to burst your bubble out there for those that are Catholics, and I want you to understand, comprehend, and then understand. I'm talking about the Roman Catholic Church. Roman Catholic Church. And it's like everything else. Not everybody is bad. I get that. Okay? So don't lump yourself in with all Catholics are bad. All right. It was anciently called trial per pious. That is, trial by the country. And now, in every criminal trial, the jury are told that the accused has, for trial, put himself upon the country. Which country you, the jury, are. What? You are. You're the country. You're the people. Huh. But see, do we even, was anybody taught this stuff? I mean, even in my civics class, when I know it was being phased out, I wasn't necessarily taught this. The object of this trial by the country, or by the people, in preference to a trial by the government, is to guard against every species of oppression by the government. Oh, you mean like the people retain the power as a checks and balance on the government itself? The legislative, executive, and judicial, all three. Would that be a power retained by the people? See the 10th Amendment? Absolutely. Huh. In order to effect this end, it is indispensable that the people, or the country, judge of and determine their own liberties against the government. Instead of the government's judging of any determining its, determining its own powers over the people? Huh. How is it possible that juries can do anything to protect the liberties of the people against the government if they are not allowed to determine what those liberties are? That's a really good question. How is it possible? How are we going to protect our liberties if, in essence, is our last line of defense before conviction or attempted conviction, judgment, to pass judgment, which I would consider a great bulwark of liberty, to defend against despotic and government and oppression, tyrants, tyranny. Why do you think they took that away from us? So they could get away with more and more and more at the end of a barrel of a gun. All right. Any government that is its own judge of and determine authoritatively for the people what are its own powers over the people is an absolute government, of course. It has all the powers that it chooses to exercise. There is no other, or at least no more accurate, definition of a despotism than this. So when they get to start determining their own powers, well, that's despotism. That is the definition of despotism. When they get to determine their powers and they get to dictate to us, that is despotism. So that's where we're at, folks. We're under this despotism. Now, like our founders wrote there in 1776 era, is that they had petitioned, they had remonstrated, only to be met with repeated injuries. Then they claimed under absolute despotism, not just despotism, but absolute, because they attempted to redress their grievances and remonstrate against passing of this legislation, only to be met with repeated injuries, which is internal insurrection, domestic violence. But we have to follow this process first before we can go to the second. On the other hand, any people that judge of and determine authoritatively for the government what are their own liberties against the government, of course, retain all the liberties they wish to enjoy. But here's part of the problem. Even if we were to bring this fully back, how many people on the jury are going to know what our rights really are? How are they going to know that what the government's doing is unlawful if they don't even know their basic rights, like liberty? And this freedom, free dominion, liberty, free dominion, Genesis 1:26 through 28. At least it is freedom to them, because although it may be theoretically imperfect, it nevertheless corresponds to their highest notions of freedom. Now, I remember reading somewhere, and it's been quite a while since I read that, but it would be better to what was that? Something about it would be better to let basically one criminal go than to convict 10 innocent men. Or no, it would, to free 10 criminals to convict one innocent man. That's right. Other way around. My bad. So basically it's saying that, it would be better to go ahead and let 10 criminals go than to convict one innocent man. To err on the side of freedom rather than government control. The edicts or dictates of government. Be better to err on the side of better judgment, of liberty. But that's the reason why the trial by jury is set up the way it is, that you got to get unanimous consent from all 12. If there is but one, and see, here it is, I found it too. It's either guilty or acquittal. There's no such thing as not guilty. And if there's one that says acquittal, that is a judgment of acquittal. That is not a unanimous consent, which we'll read here. To secure this right of the people to judge of their own liberties against the government, the jurors are taken, or must be, to make them lawful jurors from the body of the people, by lot or by some process that precludes any previous knowledge, choice, or selection of them on the part of the government. Uh-oh. Well, isn't that how they do that now? It's all selected by the government. I mean, my jury was loaded with people that are acquainted or even in law enforcement themselves. What are the odds of that many people? That was a loaded, packed jury. Oh, did I say packed? Because that's what he even says. And he uses the word packed from history. So, this is done to prevent the government's constituting a jury of its own partisans or friends. What did I just say? Packed with law enforcement? Oh, because it's me versus this police officer. Because that's what it really comes down to. That's their only witness. Oh, what did it say? Packing. All right. In other words, to prevent the government's packing a jury with a view to maintain its own laws and accomplish its own purposes. It's exactly what they've been doing, folks. It is supposed that if 12 men be taken by lot from the mass of the people without the possibility of any previous knowledge, choice, or selection of them on the part of the government, the jury will be a fair epitome of the country at large, and not merely of the party or faction that sustain the measures of the government. Huh. Let's see. That substantially all classes of opinions prevailing among the people will be represented in the jury. Let me restate that. Substantially all classes of opinions prevailing among the people will be represented in the jury. That is, if they're actually drawn by lot and without any previous knowledge of the government. Then we would essentially have different people from different walks of life, but it would be different classes of opinions. See, this is the reason why they wanted to get rid of the trial by jury and go to a jury trial that's stacked or packed against us, chosen by them, so they can make it easy. And then they say, oh, well, we just didn't do good enough. We'll call it a hung jury if there's one of the jurors that doesn't give his consent. And we'll call it a hung jury. And, well, we'll just keep trying you over and over and over again until we get it unanimous one way or the other. Till we get the jury packed in our favor, and we got them brainwashed and indoctrinated to believe and instruct them what the law is, and instruct them that you're to determine whether or not he violated this law. But it's not law. You call it law, and then you go code, Idaho Code, and then the verbiage of the Idaho Code. And especially that the opponents of the government, if the government have any opponents, will be represented there, as well as its friends. So what that means is if you're opposed to the governmental actions and you're aware of the corruption. Now, I've seen this over and over again, removing jurors because, well, I'll save that for when that part comes up because it's in here too. But I've firsthand knowledge witness of this, where they get rid of jurors when they ask them the question on this. So I'll save that for when we get to that particular point. I'll bring that back up again. That the classes who are oppressed by the laws of the government, if any are thus oppressed, will have their representatives in the jury, as well as those classes who take sides with the oppressor, that is, with the government. So you get somebody who's experienced the corruption, violated their rights, and they get on the jury, they might be more willing to go, you know what? No, government's corrupt. I'm not giving my consent for finding of guilt here because I'm aware that the government's corrupt. And I want to protect my rights. By protecting this man's rights, it's also protecting my rights. Because if a jury says no with this man, everybody else can use that. Because that's a trial by jury. That sets case precedents. Many people don't understand that one. When the jury decides no, that sets case precedents. And that's higher than any Supreme Court ruling. Even all the way up to the Supreme Court of the United States. Power of the people in the jury is the highest authority and is supposed to be paramount. But they've taken that all away from us. It is fairly presumable that such a tribunal will agree to no conviction except such as substantially the whole country would agree to. In other words, all 12. If they were present, taking part in the trial. A trial by such a tribunal is therefore in effect a trial by the country. In its results, it probably comes as near to a trial by the whole country as any trial that is practicable to have without too great inconvenience and expense. And as unanimity is required for a conviction, it follows that no one can be convicted except for the violation of such laws as substantially the whole country wish to have maintained. Now, this is what happened in my trial. There was one man who said no. He didn't think it was right that these officers out there are, on traffic stops are jerking people out of the cars. They missed one. Thank God for that one man, because that sets the case precedents right there. This is already a done deal, folks. Everything that they're doing now, it's all just fluff. It's all just show. It doesn't matter. The jury gave their verdict. 5 gave their consent for finding the guilt. 1 did not. 1 voted for acquittal. We're done. Whether that judge grants relief as demanded by me or not is irrelevant. I made my objections. I made my motion for judgment of acquittal on 2 separate times and 2 separate different sets of grounds. And I did it in writing as well and had him put it in writing. And I also noticed of the constitutionality challenge. So great, we're good. Move on to the next stage of due process of law. I could care less what they do from here. They're done. Just on that part alone. Not to mention lack of personal jurisdiction, lack of subject matter jurisdiction, defects in the prior proceedings, no grand jury indictment. There's a whole list of affirmative defenses that I already put in my motion to dismiss at the very beginning of this case. So there's a whole bunch of constitutionality challenges here. Trust me. And again, this is going to affect the entire nation. And it also, some of it, may actually affect all other English-speaking nation countries like Canada. This might have an effect on you folks up there because, technically speaking, the right to trial by jury comes from the Magna Carta. And the Magna Carta is for all English-speaking nation countries. Do you speak English in Canada? Canadian English. But you darn Canucks. Love you, brothers from the north and sisters. All right. Let's see. Maintain. The government can enforce none of its laws by punishing offenders through the verdicts of juries, except such as substantially the whole people wish to have enforced. The government, therefore, consistently with the trial by jury, can exercise no powers over the people, or what is the same thing over the accused person, who represents the rights of the people. See, this is what I've been trying to tell you folks for years. I'm doing this not just for myself. And this is what I try to teach other people to do. It's not just about you. You got to keep going. Some people want to just do the basics and motion to dismiss and win the case for themselves. I'm like, keep going. You won. Challenge it. Challenge what they did was unlawful. Go tell on them. Get the stuff taken down. Oh, no, I won. I'm good. Ugh. That's the thing, folks. What I'm teaching people is the long game. All of the process, the steps. Not just how to effectively defend yourself here, in this one court, in your one little ticket or whatever it is you got, whatever case it is, but the long game. And this is what I'm talking about. I want to train warriors to win the war, not to win just one battle. Although we do have to win the battle. So right now, people could say that I didn't win the battle. But technically speaking, I did. The battle was getting one man on that jury to not give his consent. And they're done. Whether they like that or not, whether they recognize that or not is irrelevant. But the key is, the long game, I'm going to do the constitutionality challenge. And I can guarantee you, when it gets up to the Supreme Court of the United States or Congress, whichever one decides to take this, because this is more internal insurrection, because Article 4, Section 4, I think this is more of a political argument, not a judicial one. Under Article 4, Section 4, Luther versus Borden, says this is a political argument, not a judicial one. And under Article 4, Section 4, the true intent behind guaranteeing a republican form of government was to keep us from turning us back into a monarchy and instituting this absolute rule or despotism onto the people again, even in one state. Because that's what domestic violence is. Internal insurrection, an attempt to overthrow the Constitution, the law of its creation, and war against the people. That's what domestic violence is. Not what we've been led to believe since 1995 with the Violence Against Women Act, which in 2000 in the U.S. versus Morrison case declared parts of the domestic violence thing unconstitutional, and then they did their Reauthorization Act in 2005. No. How do you reauthorize something that's unconstitutional to begin with? Well, because nobody's challenged it. Make no mistake, I got that one on the back burner. I have standing for cause of action on that one too. Those who've been around long enough know about what I did with Timothy Charles Homseth. And anybody who wants to read that paperwork, go right ahead. Go get that court of record from the Minnesota East Grand Forks District Court there in Timothy Charles Homseth's case. And get the documents from the record. And you tell me who won. There was no objection by the prosecutor at all. No rebuttal, no objection to the motion to dismiss. I hammered the crap out of them, and they know it. And we were at default judgment. And, of course, Timmy didn't read the paperwork. He didn't listen to what I told him about the rules of procedure and what it said. And I told him just read from his paperwork. We had him. It was a done deal. But she asked him questions about his own paperwork. to see if she was testing him, to see if that he knew his own paperwork. And this is, again, perfect example of what Tony Pellegrino and I both talk about helping people do their paperwork, and they don't even know their own paperwork. They don't know the law behind it. They don't know the law that's in it. It does no good when they go to test you and you don't know it. That's the problem with that, and that's why I don't do that anymore. You're going to have to learn how to do this for yourself. I'm not going to do this for people anymore. All right. Or with the same thing over the accused person who represents the rights of the people, except such as substantially the whole people of the country consent that it may exercise. In such a trial, therefore, the country, or the people, judge of and determine their own liberties against the government. Against the government. Instead of the government's judging of and determining its own powers over the people. What you talking about, Mark? I'm an old dog. I'm learning new tricks. Hey, I don't know everything. I don't claim to know everything. That way I can't be held to know everything. But you learn something new every day. And guess what I learned today was what I learned yesterday was wrong. The day we stop learning, we might as well just curl up and die because you think you're just too good for the world if you know everything already. But all this trial by the country would be no trial at all by the country, but only a trial by the government. If the government could either declare who may and who may not I don't know if there's something else, be jurors, or could dictate to the jury anything whatever, either of the law or evidence that is of the essence of the trial. If the government may decide who may and who may not be jurors, it will of course select only its partisans and those friendly to its measures. This is exactly what just happened to me. It may not only prescribe who may and who may not be eligible to be drawn as jurors, but it may also question each person drawn as a juror as to his sentiments in regard to the particular law involved in each trial, before suffering him to be sworn on the panel, and exclude him if he be found unfavorable to the maintenance of such a law. So, also, if the government may dictate to the jury what laws they are to enforce, it is no longer a trial by the country or trial by jury. Now, this is where it talks about the part I was talking about, and this is that star up there, footnote. To show that this supposition is not an extravagant one, it may be mentioned that courts have repeatedly questioned jurors to ascertain whether they were prejudiced against the government. That is, whether they were in favor of or opposed to such laws of the government as were to be put in issue in the then pending trial. This was done in 1851 in the United States District Court of the District of Massachusetts by Sprague, the United States District Judge, in impaneling 3 several juries for the trials of Scott, Hayden, and Morris, charged with having aided in the rescue of a fugitive slave from the custody of the United States Deputy Marshal. What? This judge caused the following question to be propounded to all the jurors separately, and all those who answered unfavorably for the purposes of the government were excluded from the panel. Wow. Started in 1851. tell you. Knowledge is power, folks. And I'm trying to empower you folks by giving you this knowledge and sharing this with you. And the beauty of these videos, you can go back and watch them over and over and over and over again as many times as you need to get it. Now I got to go back up because I forgot where I left off verbiage-wise. The end of the yeah. So also, if the government may dictate to the jury what laws they are to enforce, it is no longer a trial by the country, but a trial by the government, because the jury then try the accused, not by any standard of their own, not by their own judgments of their rightful liberties, but by a standard dictated to them by the government. And that's exactly what they do. And the standard, thus dictated by the government, becomes the measure of the people's liberties. If the government dictates the standard of a trial, it of course dictates the results of the trial. And such a trial is no trial by the country, but only a trial by the government, a jury trial. And in it, the government determines what are its own powers over the people, instead of the people's determining what are their own liberties against the government. In short, if the jury have no right to judge of the justice of a law of the government, they plainly can do nothing to protect the people against the oppressions of government. For there are no oppressions which the government may not authorize by law. That's right. The jury are also to judge whether the laws are rightly expounded to them by the court. Unless they judge on this point, they do nothing to protect their liberties against the oppression that are capable of being practiced under cover of a corrupt exposition of the laws. If the judiciary can authoritatively dictate to a jury any exposition of the law, they can dictate to them the law itself, and such laws as they please. Because laws are, in practice, one thing or another according as they are expounded. So we're going to go by the 4th, 5th, and 6th Amendment, or are we going to go by what the judge instructs the jury the law is? That's what we're dealing with. That is exactly what just happened to me. The jury must also judge whether there really be any sufficient law. Can't be that long. Any such law, be it good or bad, as the accused is charged with having transgressed. Unless they judge on this point, the people are liable to have their liberties taken from them by brute force without any law at all. Even if we were to apply the Idaho Code, in my own case, okay, I'm being charged with resisting and obstructing, but where's the other charge? Where's the primary charge? Where's the crime? Where's the lawful arrest that he was making to begin with in order to resist a lawful arrest? Because it would have to be a lawful arrest first. And if it was a lawful arrest for a traffic infraction, the public prosecutor would have filed those charges. But they didn't. They didn't file any of those other charges. Why? Because I already defeated that crap back in 2014. Don't have to have a driver's license. I don't have to register. I don't have to follow any of that stuff because I'm not part of commerce, not acting in commerce. I don't seek permission to exercise any of my rights. Now, remember, as I read from the Bible here quite a while ago about they go to make legislation, we have to ask the simple question, what is the intent? But what is the intent? What is the evil that it is intended to stop, to prohibit? What's so evil about getting in my car, my personal property, and going from my home over to Quickie Mart, getting some cigarettes? Where is the evil in that? Who did I hurt? What's the name of the man that has standing to claim a right to a cause of action here? Bingo. There is no cause of action. There is no standing. This goes back to the Magna Carta, that they're not going to try to prosecute us on an unsupported complaint of the bailiff. Now, that's in the Magna Carta. Number 39 there. There's a 38. 39. That, the bailiff was the sheriff. Or the bailiff back then is now the sheriff. And so sheriff representing the executive power, this what we've been dubbed as law enforcement. They're supposed to be law executors to execute the law. It's the executive branch. They're supposed to be doing what they're told to do. But there again, those words, diction. We enforce the law. No, you do not. You execute the law, which means you have to know the law and you have to follow it as it is dictated to you, the executive branch, to execute the law, not enforce it. The jury enforces the law. They also are supposed to judge the law. See how that works? But that's clear back to the Magna Carta that they wouldn't do this stuff. And that's what this is a police officer, a policy officer out there charging me with resisting and obstructing, but it's not supported by an accuser. What's the name of the man under oath here? Because, the police officer, he's an agent, and an agent cannot act on behalf of a principal if the principal doesn't exist. That's that probable cause. Where's the principal? Oh. Yeah, I don't know about that. The jury must also judge whether there really be such a law, be it good or bad, as the accused is charged with having transgressed. Unless they judge on this point, the people are liable to have their liberties taken from them by brute force without any law at all. That's what they're doing. If you don't follow their commands, they call it lawful orders, but they're not lawful, not full of law. None of what they do is lawful. None of it. They don't follow law. They don't even follow their own code. The jury must also judge of the laws of evidence. If the government can dictate to the jury the laws of evidence, it can not only shut out any evidence it pleases, tending to vindicate the accused, but it can require that any evidence whatever that it pleases to offer be held as conclusive proof of an offense whatever which the government chooses to allege. I mean, this is what we're all being subjected to. No, the evil is not the cigarettes. Good Lord. What's the name of the man that I caused harm to? That's the evil that gives rise to a cause of action or reaction. If the government can dictate to the jury the laws of evidence, it can not only shut out any evidence it pleases, so that's denial of exculpatory evidence, tending to vindicate the accused, but it can require that the evidence, whatever it pleases to offer, be held as conclusive proof of an offense, whatever which the government chooses to allege. And that's exactly what they do. They even instruct the jury. Don't worry about anything else. Did this defendant here, did they violate the verbiage of the code? They say law. Sometimes they'll say statute. It is manifest, therefore, that the jury must judge of and try the whole case, and every part and parcel of the case, from of any dictation or authority on the part of the government. Yeah. And see, when we actually say trial by jury, it starts with the grand jury. The full jury, because like it says in the Fifth Amendment, in all criminal processes shall have an indictment or presentment of a grand jury in all capital or infamous crimes. Oh, what do you mean by infamous? Those what the Roman civil law calls felonies and misdemeanors. Common law, we call that capital or infamous. See that diction? But it's supposed to start with the grand jury, or the common law grand jury, does the indictment and presentment. Then, and only then, can you move to a petite jury, trial by jury. Because the trial initially starts with the grand jury. And all the pleadings and everything from there on, all the way up to the end with the trial by jury, is the trial in the trial court. And so the bigger picture here is every time you do something, you make an objection, a motion, whatever, and it gets denied, that is an appealable issue. So don't fret. They want you to get all worked up and frustrated and mad and pissed off. It's a psychological warfare. But I'm telling you right now, folks, they're all by evil design to deny. It's a psychological game. They want to see if you know what to do after the trial court. Do you know how to appeal? First of all, do you even know how to conduct your own trial from beginning to end? Then, what do you do after that with all these errors? That's the key. So, they must judge of the existence of the law, of the true exposition of the law, or intent, of the justice of the law, and of the admissibility and weight of all the evidence offered. Otherwise, the government will have everything its own way. The jury will be mere puppets in the hands of the government, and the trial will be, in reality, a trial by the government and not trial by the country. By such trials, the government will determine its own powers over the people, instead of the people's determining their own liberties against the government, and it will be an entire delusion to talk, as for centuries we have done, of the trial by jury as a palladium of liberty, or as any protection of the people against the oppression and tyranny of the government. Whew! That was a mouthful right there in just that one sentence. By such trials, the government will determine its own powers over the people instead of the people's determining their own liberties against the government, and it will be an entire delusion to talk. In other words, delusional. You're crazy. This is crazy talk, Kirk. You don't know what you're talking about. We can do a trial by jury, a jury trial of 6 men in misdemeanors. See, it says here in the Idaho Constitution, Article 1, Section 7. What about Article 6, Clause 2, the Federal Constitution, the supreme law of the land? The judges in every state shall be bound thereby. Anything in the Constitution or laws of the state to the contrary is notwithstanding. Oops! See what I'm getting at, folks? I'll be even challenging the entire Idaho Constitution. The whole thing. But you have to understand the bigger picture there. It was never submitted to Congress for ratification by Congress. Found that in legislative session from Congress, the de facto Congress, stating that Idaho and certain other states didn't need to submit their constitutions to Congress for review and ratification. Imagine that. As for centuries, we have done. Talked about this stuff for centuries. Well, apparently we haven't. We've been derelict in our duties. Okay. Of the trial by jury as a palladium of liberty, or as any protection to the people against the oppression and tyranny of the government. Are we seeing the importance of the trial by jury on a much bigger, grand scale? Yeah. But I mean, I'm asking that question. Are we seeing this? Just from reading this right here. What the benefits of trial by jury is? Perfect. Good one. Out here on Rumble. Red 1776 pill. Knowledge is power. Even Yeshua fulfilled the law. And it's up to us to keep it or we will lose it. Please, people. Please learn. Please study. It's for the benefit of the whole. We have to have this knowledge. If we don't have this knowledge, we have no power. And we need to have the people educated. We have to empower ourselves. And I can tell you right now from firsthand experience, many times now, this knowledge has literally empowered me, and God has spoke through me in the moment. And I have struck down evil. I have made them flee from me. Just like walking into a room full of cockroaches and turning the light on. They flee like cockroaches. Because when I speak the law, it's like wielding a double-edged sword. They want to get the heck away from me because I'm wielding that double-edged sword in the spiritual realm. I'm cutting them down. I'm convicting their soul in the spiritual realm. So, you know, really, really, really need to learn this stuff, folks. We need to learn what our rights are. We need to learn how our true Republican form of government is, the way it's supposed to be, so that we know what comes in conflict with it is void for any effect. It's great to know and learn about the fraud stuff, but if you never learn the truth and how things are supposed to be and what the real law is, we're never going to get anywhere. And that's like 90% of the problem with a lot of people out there that talk this stuff. Oh, it's all fraud, this, that. Yeah, great. So what's the real law? What's the real remedy? What's the real relief that I can gain following due Oh, but then that they don't have any. All right. Let me go just a little bit more. The question then between trial by jury, as thus described, and trial by the government, is simply a question between liberty and despotism. The authority to judge what are the powers of the government and what the liberties of the people must necessarily be vested in one or the other of the portion themselves. The government or the people, because there is no third party to whom it can be entrusted. If the authority be vested in the government is absolute, and the people have no liberties except such as the government sees fit to indulge them with. That's the Roman civil law under the monarchy, folks. They call them civil rights or privileges. You only have those rights or privileges as the government dictates or the king dictates. Under law of nations, laws of nature, and American common law, by and through the English common law. But even Blackstone makes a very clear distinction between the English common law and the American common law. Make no mistake. He makes it clear in there. He'll say something about the English common law and that kind of stuff. Then he'll say, oh, but in America, it's this way. That's the American common law. Starting in 1606, we started creating the American common law. They brought with them the English common law, but only those parts that were conducive to the public weal. And they pick and chose, and we started creating a brand new form of government, essentially starting in 1621 with the Ordinance of Virginia, creating that General Assembly and the General Court. Whoops. Gee, would that be that part of that common law grand jury court of justice? The General Jural Assembly. So the authority to judge what are the powers of the government and what the liberties of the people must necessarily be vested in one or the other, or the parties themselves, the government or the people, because it's entrusted. If the authority be vested in the government is absolute, and the people have no liberties. Yeah, that's where we're at. Except such as the government sees fit to indulge them with. So what are we going to do about it, folks? Hi, Scrimshaw. You can see on here the late. If, on the other hand, the authority or that authority be vested in the people, then the people have all liberties as against the government, except such as substantially the whole people. Oh, I get off a little bit. The whole people, through a jury, choose to disclaim. And the government can exercise no power except such as substantially the whole people, through a jury, consent that it may exercise. Now, this is part of the grand jury process, remember. The whole trial starts with the grand jury. And the grand jury is supposed to determine this stuff too. And if they don't come back with a grand jury indictment and present it, done deal. There is no case. Oh, yes, absolutely. Been asked here on Rumble if Carl Miller is a great guy to follow. He's dead, but his information is still out there. Absolutely. And in fact, Carl Miller was part of assembling Michigan back in the day. Carl Miller actually lived with Destry for a little over 2 years. These are the guys that know what the heck's going on. These guys have already done it. They've already got government de jure started, set up in essentially in Michigan and Alaska. Carl Miller is essentially the only man I've ever really watched his videos and learned from him. And the fact is he's the man that inspired me. What did he say? Oh, somebody ought to do something about this. And he said, be a somebody. And the other one that he says is, we got to start studying this stuff. You got to learn this stuff. You got to commit it to memory and be able to rattle this stuff off the top of your head. And when I came across that back in 2014, I'm like, man, I'm starting to get old. I don't know if I can, remember this stuff. And, here it is, 9 years later, almost 10. My memory's still pretty darn sharp. But for me, a lot of this just makes common sense to me. I get it with ease. Like, oh, yeah, it makes sense. We should have a jury of 12 men, and yeah, they're supposed to judge the law. That's to ensure that our rights are protected. Because when you're sitting as a jury, you're one of the people. And the decisions you make there against your fellow man, also one of the people, can turn around and bite you in the butt because you didn't defend his right, which you hold the same right sitting there in the jury. But then again, did they take over? They sure did. It's time to take back our power, folks. We have to get educated. We got to gain this knowledge. If we do not have this knowledge, we have no power. Right? Be a somebody. I know, right? Absolutely. Carl Miller said that one too. If you don't know your rights, you don't have any. In fact, it's even some of the early constitutions of 1776 era, when they finally started making their own constitutions, and Virginia was giving them, the land, seceding land to them. It says right in their beginning of their constitutions, talks about you have to confess that you believe in God and claim these rights, and if you don't have these rights. So why do you think they want to get rid of God from government? Oh, separation of church and state. Absolutely. Congress shall make no law establishing religion. That's because they didn't want Congress to be able to change from Christianity as our ideology back into Catholicism. See Article 4, Section 4. Or expect the free exercise of religion, which is liberty of conscience, the right of self-determination, free will. We get to think for ourselves. Heaven forbid that we say no to something that the government says we're supposed to do. Well, I have free will. God gave that to me, and that includes telling you no and to F off if I so feel like it. And there ain't jack you can do about it. Kick rocks, buddy. If you don't like it, tough cookies. Go kick some rocks somewhere else, buddy. Don't be come messing around with me. All right, so in closing, folks, I want to put this out there again, and I'm becoming doing this on a regular basis now, just to make sure everybody gets this. My website, kirkslawcorner.com. There's my Facebook page, Telegram channel. This gets you to Patreon. That's for those that want to help support here digitally. That's the way I can. That's the only way I've got that able to work, because they took down my PayPal, my Cash App, my Venmo, right? That's what they did to a lot of the patriots back in the day. Well, I'm one of them. So, through Patreon, you can set whatever you want to donate a month, or you can do like tier 1's $5 a month, tier 2 is $10 a month. You know, it's a cup of coffee essentially. A month, one cup of coffee. That was one that I thought about looking into, about buying me a cup of coffee or whatever for donations. So I haven't gotten around to fully implementing that one yet, but that may be a possibility. But as of right now, that's how I'm doing this. Otherwise, you can mail stuff to the office, which is the address is down here at the bottom. Send it to Kirk Pendergrass, 6477 West Fairview Avenue, Suite C, Boise, Idaho 83704. If you want to make any kind of donations to me to help support me and what my endeavors here and what I'm working on and everything I'm doing here for free, okay? Otherwise, if you want to get in on our Wednesday night workshop, that's tier 3. And then if you want one-on-one time with me, that's tier 4. Now, right here, get you to the first episode of the educational series. Now, I'm actually kind of curious. If you go to the end of this, does it go automatically to episode 2?
No. That might be not until next week.
Let's see what happens here. Does it roll over to episode number 2 automatically? I have to wait there. But this free educational series there, and on YouTube, I have added actually 4 videos there, 3 of my own and one that's I think people should watch. So there's more than just the 8 now, and I've been half tempted to redo some of these, but you know, the reality is they're already done. They're for free. They're out there for free. Just talking about the law, trying to educate the people. Okay? Let's see what happens here. Because if not, you got to go over to the YouTube channel to get to the other episodes in the playlist. Oh yeah, see, it'll take you to episode 2 right here. Because it's in the playlist, so more than likely it'll play all of them in that playlist. Otherwise, let's see, what does it say here? Watch later, share. Yeah. Otherwise, you can just click on YouTube, which will take you over to YouTube. And then what you'll want to do is click right here where it says Kirk's Law Corner. That'll you go to my channel, and then you'll go to playlists. Now, of course, I can see, okay, here's the educational series. Full playlist. Look at that. And what's weird is, like, episode 5 actually has the verbiage still there. All the rest of them, they've taken the verbiage off, but they put it in under, and they did hide one video. That was the one that Chris and I did for the 3 hours, 33 minutes, and 34 seconds. Going over how E-Clause came about and what E-Clause was all about, and the documents, and proving everything to certain people out there that didn't think that it was legitimate, which it was. But you'll notice that on any one of these, you look in the description here. But I did these in a chronological order of things. That's why they're numbered, episode 1 of 8. What are your rights? Where do they come from? In law as it is written. Okay? And I don't know, somebody's been doing key moments here or something. I don't know, or YouTube did that. But notice when this was done. October 1st, 2000. Actually, that's when I uploaded them here. October 1st of 2019. Over 4 years ago, folks. Now, just for those, we're right here. I think it was it episode 7? No, I think it might be episode 6. No, episode 6 was lawful notification letters. Maybe it was number 8. Where I went over executive orders and stuff. Oh, this is the consumer fraud protection and habeas corpus one. Yeah, this is the executive order 13844 right here. But this is also... Yeah, this is Executive Order 13818. So, Episode 8 is 4 years ago. Yeah, see, I uploaded these. I actually did these much longer before that. Before I had to download these off of Facebook and then put them on YouTube. So, generally speaking, these are probably five years. Can't remember. But anyways, Episode 8 of 8 is the one where I went over the executive orders over 4 years ago. Laying this stuff out, what was going on in the educational series, which I was already going over them as they were coming out through 2017 and 2018. So here's proof that I was putting this stuff out before Derek Johnson even come on the scene. Yep, that's Executive Order 13818 right there. I know the verbiage from that executive order. So, again, prima facie evidence that I was putting this stuff out long before Derek Johnson came out. Now, the other ones that are up here, YouTube, we'll take you to YouTube channel, and Rumble. Now, the other part here is the library. Treatise on Arrest and False Imprisonment. It's Treatise on Arrest and False Imprisonment, not Treatise on False Arrest and False Imprisonment. It's Treatise on Arrest and False Imprisonment. Because if the arrest is not lawful, it becomes false imprisonment. Then the Authority of Law. Both of these are by Charles Wiseman. Here's the Law of Nations. Here's the Report of the Commission on Unalienable Rights. Here's your our Lex Parliamentary Americana, Elements of the Law and Practice of the Legislative Assemblies of the United States of America by Luther Stearns Cushion. Now when you get the 2010 edition manual, Mason's Manual of Legislative Procedure, and you open that sucker up and you start seeing that cushion as footnotes, that's this book right here. So in my mind, Mason's Manual of Legislative Procedure subverts. This is the bar way of doing things. Because they can't go back to 1856 and get rid of this book. Because it's already been done, published, and printed all over the place. In fact, right here on my desk. Thank you to the man who bought that and sent that to me. Then I've got the Jefferson's Manual right here. And then the 1953 edition of Mason's Manual of Legislative Procedure. Then I got Joseph Story's Commentaries on the Constitution, Volume 1, 2, and 3. I need to get some other ones up here, man. I need to get the Blackstone's Commentaries on the Law of England up here. This one's Bouvet's Law Dictionary, 1856. This one right here is such a good one. Black's Law Dictionary, 4th edition. And here's your Maxims of Law, Right here. Book on Maxims of Law. I did put up that Virginia Declaration Right, County Sheriff's Handbook, 1776 report. This is that report, 1776 from Trump. Now here's my brief on the right of personal liberty, also known as the right to travel brief, but it's actually the right of personal liberty. That's why I changed it. This is essentially what I filed back in 2013 in the 2013-2014 case that got dismissed, that I have not had a driver's license since. Okay? I can't remember what the parliamentary inquiry, that was Chris, something to do with Chris there. So there's one little tidbit there from stuff we did with Chris there. But lots of books to read from there. And then ultimately, we need to come here. national-assembly.net. Okay? Every Thursday night, there's a conference call. It's called the free conference call. Is it not working? Okay. Conference call every Thursday night, 6 p.m. Pacific, 7 p.m. Mountain, 8 p.m. 9 p.m. Eastern. The very first part of it's the assembly business stuff. The second part is the general discussion, education portion, and Q&A. Okay? Here's two videos for your smartphones on YouTube to watch and learn how to use the free conference call. Here's a video how to use it on your desktop. Download the program, folks. Install it either on your phone or your desktop, laptop, whatever you're using. Highly recommend installing the app. Okay? But you can also just dial in. But fees may charge on that. Let's see. The resource tab. There's your 10 steps to an assembly, important censored videos, assembly supporting videos. There's the training manual, 2000-25. That's the military manual, the citizenship manual that Oscar and I've done video on. Oscar did an overview on the National Assembly calls. Jason from his Hardline, he did one on it. I have yet to do one on my own yet, but I'm more focused on some other things. Obviously, taking down corruption, taking down stuff that's unlawful and unconstitutional, and setting things straight for us, at least in the right direction. But in the end of all of this, folks, we need to reassemble government de jure. And these guys are the only ones that are doing it lawfully, correctly, and have the military support. Now, where was that? I wonder if this one here from his hardline, Corporate America, voiding the Act of 1871. Because there was 21 requisitions that was done by the Michigan General Assembly. Here we go. Issued. We have our assemblies. What have our assemblies accomplished? Michigan settled as a de jure state interim in 2013 and recognized by seven foreign countries. Issued 21 requisitions to the Joint Chiefs, Judge Advocate General, and the Pentagon, 12 of 2011, resulting in putting Trump into presidency, Space Force, and much more. Stopped Obama from going into Syria with boots on the ground September 10th, 2013. Voiding the Act of 1871, causing the Queen to lose her power and walking behind Trump, and Trump inspecting the Queen's military. Act of 1871 voided, rendering D.C. as a dead foreign crown-owned Vatican-run city-state, and our country defaulted to military control. Alaska, with unrebutted original nation-state settlement, November 5th, 2020. Is there any other group that can claim anything like this? There's a good question. And they can't. Ain't none of these fake wannabes out there done anything. One can only teach from experience, and they have it. We have it. All we have seen from other groups is people getting nowhere or ending up in jail. Same thing what I've found. All talk, no action. We're gonna do, yeah, right. You haven't done anything. Because you're not legitimate, and you know you're not. Sounds good. On paper. But try to take some action on it, and you'll find yourself in jail. Promise you that. And that's our civil peace flag, folks. That's the one I have hanging on the back of my chair here. The other one is the war flag. But, I've looked for this, what Carl Miller talked about in his movie. He's talked about that, or videos, Project Blue Book. And this was the training manual that he was talking about. The TM 2025. That's exactly what Carl Miller was talking about. And teaching people, basically, how to reassemble our government. Government de jure, and take back our power. Trump already said he was putting the power back into the people's hands at his inauguration speech. So where are we at? People? No, you don't have to change your status. This is changing your status. From man, inhabitant, to one of the people. Or you can just claim it. There is no such thing as state national other than from the code, which was created in 1878. So think about that real hard. People don't even realize where their source of law is coming from, and the definition, like I've already showed from etymology. National, as a noun, didn't come into being until 1878. Huh. But what did we call people back then, before that? Oh, we called them citizens, which are the public servants, the members, who are bound, and then the inhabitants and the people. Those are the statuses you want to have here in America, in our true republican form of government, government de jure, lawful government. You either want to be an inhabitant, you want to be one of the people, or you want to be a member of the legislative, executive, or judicial branch who's bound by oath or affirmation to support the Constitution. That's when you become a citizen. Okay? No, we're not born nationals. Nationals is shit made up. It doesn't lawfully exist. I just went over that. Think about it, folks. Right from the Law of Nations. Book 1, Chapter 19, subsection 212 and 213. Go read it. There's your definitions of what a citizen is. That's 212. 213 is inhabitants. And yeah, there's a different kind of citizen in between the inhabitant and the public servants. We call that the people here in America. So it's a different kind of citizen. Right? Artists' Confederation. Free inhabitants, free citizens. Huh. Why free? Huh. As opposed to slaves. Because we're endowed by our Creator with freedom, free dominion. I don't recall reading anywhere in the Bible where it says all white men are free and everybody else of any other color or skin are slaves. So I'm going with God's intent that we're all created equal. I don't care what your skin color is. Shouldn't have any bearing or effect on God-given natural rights. The right of liberty, the right to think for themselves, the right to do whatever the heck they want to do. So long as they're not causing harm to me or causing harm to my fellow man, what do I care? None of my damn business. Keep my nose out of their business. Their business is none of my business unless they make it, which gives me cause of action to react to whatever actions that they're taking. They're destroying property. Yeah, I'm going to try and stop that. Hey, what's going on here? Hey, what, you know? All right, folks. You're welcome, Red Pill out there on Rumble. Yeah, that's we're born creations of God. Read the Bible, right? Genesis 1:26 through 28. God created man. God's the sovereign. God endowed mankind with sovereignty, and we are sovereign over that which we create. We're sovereign in our own right. So, but you have to know this. You have to claim that. Can anybody rebut it? No, they can't. I mean, they've tried with Darwinism and evolution, but there's the missing link. Yeah, it's called a brain cell. You ain't got one. I can't even begin to imagine how everything came into being if there wasn't some sort of a creator. I mean, I'm a pretty sharp guy, and I could try to think of other ways, but it's impossible to create something from nothing unless they're outside of what's been created. Yeah, technically speaking, the Bible is the law. And here's the thing about what I found in Blackstone's commentaries on the law of England. The root of Christianity, the root of the common law, the origin, the very beginning of what is known as the common law, is maxims of law and customs from the Christian religion, from the Saxon side. You remember Anglo-Saxon? Not Judeo-Christian, but Anglo-Saxon. So the Saxon side is what created the common law as a fundamental law, as opposed to the Roman civil law, the code, or theocracy, feudal system. Okay? That's your other type of fundamental law. So that's an ideological conflict between Christianity and Catholicism is the main two ideologies, a set of ideas for government. What's fundamental, and then what is government? What's the form of government? It's an ideological conflict. Plain and simple. Read the Magna Carta. Fully comprehend the trying to separate from the Roman Catholic Church. Because that's who's at the root of this problem here. All throughout history. I mean, the crap was lost supposedly at the Lombard invasion, which it was around 600 AD. So why? Why did it come back in 1130 AD when it was rediscovered? We could have just left that suck buried. Leave it alone. No. Got to bring back that Roman civil law, the code, and take back all this power. So, again, we cannot deny those truths, those facts, documented facts. Several different places that say the same thing. Bouvet's Law Dictionary 1856 says it. Blackstone's Commentaries on the Law says it. So, All right, folks. Have a good evening, folks, and thank you all for those that have supported and are supporting. And again, if you want to send any cash, wrapped aluminum foil, gold, silver coinage, money orders, anything like that, send that over to the office to me. Address is on the website, kirkslawcorner.com. All right, folks. God bless you all. Have a